Good afternoon, everyone. We're going to call the meeting of Children and Family Affairs Subcommittee to order. Haley, would you please call the roll?
Representatives Bricken, Eldridge, Farmer, here. Gillespie, here. Harris, here. Stewart, here. Chairman Littleton.
Here.
Madam Chairman, you have a quorum.
Thank you, Haley. I have a personal order today. I have Kinsey Gosner with us. She is Megan Frazier's daughter. She's over here. Would you want to stand up so everybody can say hi to you? Thank you for being here. Do any of you others have a special personal orders or comments? Hearing none, we're going to move on. We'll do a little housekeeping. Item number 17 has been taken off notice by request of the sponsor. So next, without objection, we're going to call them up out of order. We're going to call up item number 1, House Bill 2712 by Chairman Howe.
Motion. Second.
Properly motion and second. Chairman Howe, you're recognized.
Thank you, Madam Chair.
And I see you do have an amendment.
I do have an amendment that makes the bill. My number is 015942.
And it is untimely, is that correct?
That is untimely file.
With that,
if I may, Madam Chair. It was a technical change. That's why it's untimely.
It's just
we
a
did
little
it late
technical
last
change,
night.
but do I? Yes, we started with number 2. I'm sorry, I thought I said that. So we're going to vote on taking up Amendment 15942 untimely. All those in favor say aye. Aye. Those opposed, no. The ayes have it. You are now recognized on House Bill 2712 as amended. On the amendment, I'm sorry.
I'm sorry.
You are now recognized on the amendment.
Okay. As I said, the amendment makes the bill, so I can explain the amendment.
Okay. We'll go ahead and properly motioned and seconded. You're recognized on the amendment now.
Okay. This bill, as amended, is the result of the Joint Refugee Study Committee that was appointed by the Speaker and Lieutenant Governor back in the summer months. And it contains the recommendations from the committee's report. And it would put in place some additional safeguards and reporting requirements for residential placement child care agencies.
Chairman, I don't think we put the amendment on. Can you just describe what the amendment was and let us put it on and then go forward? If that's okay.
That was my description.
Okay. So all those in favor of Amendment 015942 say aye. Aye. Those opposed, no. The ayes have it. Now, we're in the proper place. You're recognized.
Okay. You want me to continue?
Please.
Thank you. It provides additional safeguards and reporting requirements for residential placement child care agencies such as, for example, Bethany, who has been doing business in Tennessee and placing children like foster children in residential homes. That's called an RCCA, residential CCA. This bill requires the residential child care agencies to disclose all contracts and agreements with third parties who provide care, housing, or placement of children in Tennessee. The requirements must be met in order to receive a new license for a new facility or a license renewal. The bill creates a license revocation requirement for RCCAs if an employee is charged with criminal offenses related to their job responsibilities, including offenses related to the children in the agency's care. And finally, the bill creates reporting requirements including the facility census, the name and name list upon request. It creates an annual report of children served, the disposition of children transferred from that agency, a reason for the transfer, and any contracts or agreements with third parties. This bill was drafted, I would add, in consultation with the Department of Children's Services, who is deferred on the bill, and that's the bill.
We all know that that was a terrible situation in Chattanooga that we had, and something does need to be done about these things, and this looks like it's probably a good start as far as I can see. Do any of the members have any questions for Chairman Howe?
Call the question.
Question's been called. Any objection? Hearing none, all those in favor of sending House Bill 2712 to civil full, say aye. Those opposed, no. The ayes have it. It moves out to civil full. So now we'll move back to item number 1, House Bill 2711 by Chairman Howe. Chairman Howe, you are recognized.
I do have an amendment, ma'am,
And
that
there
makes
is
the
an
bill.
And that drafting code?
I have 1015436 is what I have.
Do we hear a motion on the amendment? Properly motion and second. Does it make the bill?
It makes the bill.
Okay,
yes,
since
ma'am.
it makes the bill, let's go ahead and put the amendment on. All those in favor of Amendment 15430 going on to House Bill 2711, say aye. Those opposed, no. You are recognized on the bill as amended.
Thank you, Madam Chair. As you mentioned, this past summer, there were several news reports of unknown numbers of unaccompanied alien children, or UACs, as they're called by the federal government, being brought into Tennessee. A UAC is by definition from the federal government an illegal alien, a minor who is under 18 with no legal immigration status. Our committee hearings, which I co-chaired with Senator White, during that hearing, it brought to light, to me, a shocking lack of transparency on the part of the federal government in letting states know what's happening to these minor children. That includes anyone under 18 years of age. And in response, this legislation creates a new category of child care agency called the Non-Traditional Child Care Agency. Instead of an RCCA, it's an NCCA. And this new NCCA will be specific in addressing those agencies, such as the one involved with the issues in Chattanooga that provide on-site housing instead of placement housing, on-site housing, such as a dormitory where those children were housed in Chattanooga, and for children who are transported across state lines who are not subject to the Interstate Compact on juveniles or the Interstate Compact on placement of children. These children are not subject to the compacts because they are under a federal jurisdiction. And so the states have no standing in that regard, but as the feds do not and have not shared any information about the status of these children with the state, however, the federal law agrees with state law that the states are responsible for the welfare and safety of minor children within its borders who are not under parental control or do not have a legal guardian, such as these children were. And the state also is responsible for the licensing of these NCCAs in order for them to house these children. So with that in mind, through the creation of this new agency, the NCCAs, the state of Tennessee will be better able to ensure the safety and welfare of these children who do come into our state, who are not under state control, but under federal control. But the feds agree that we have responsibility for their welfare. So how do we do that? Well, that's the result of the committee hearings, and that's the result of this bill. It contains reporting requirements to ensure that the DCS knows who is being brought into the state. Previously to this, we had no idea. But it will create a reporting requirement from the NCCA to the state. A database will help ensure safeguards against child abuse by establishing a known record of the children that are served. It limits the number of children that can be housed in a facility, such as the one in Chattanooga, to 25. That one was licensed for 100, which we all agreed was way too many for one facility. It creates a cause of action against a NCCA for a child who may have been subject to abuse at that facility. The application fee for these NCCAs is $25, as well as a $100 fee per child that the agency is licensed to care for during its license period. So these are some pretty good safeguards that we felt like we were capable and able to put on in spite of the lack of cooperation from the federal government. I believe these safeguards are reasonable. I believe they will help protect the children who find themselves in these situations in the future. And again, this bill was drafted in consultation with DCS, who is also deferred on this bill as well, Madam Chair.
Thank you, Chairman Howe, for bringing this. I think we were all disturbed about the children and what did happen to them, but I think maybe I should correct myself. I think they were young youths instead of actually small children, but it was still, what happened to them was not right. And we need to make sure that things do not happen like that
Yes.
again. So thank you very much for bringing this bill. Are there any other questions for Chairman Howe? Representative Stewart?
Have you talked with Representative Rudd about his bill that addresses this similar issue? And if so, what's the plan? Pass both bills, neither bill? What's the?
Chairman Rudd's bill failed in civil a few minutes ago. Chairman Howe, you're
Yes, I was going to tell Representative Stewart that we had a conversation about 2 weeks ago, and he agreed that he would continue to run his bill, but I understand it did fail.
But I guess my question was, I should have
Representative
clarified.
Stewart.
Thank you, Madam Chair. I should have clarified because, again, an hour ago, you were moving your bill, he was moving his bill. That bill just, how were they intended to interact, or were they not? Were they essentially competing bills, or bills are trying to address the same thing in different ways? How would you describe them?
Chairman Howe.
They were independent of each other. My bills came out of the study committee that I co-chaired. He was not on that committee, and I was not aware that he was running a bill until he told me after session had started.
Okay, that answered my question. Thank you.
Representative Harris.
Thank you, Chairwoman. So on this bill, I guess the difference would be that this is related to agencies rather than the individual homes, correct?
Chairman Howe.
Yes, this has to do with non-traditional agencies that actually house children in dormitory-type facilities, which is what was happening in Chattanooga. And I might remind the committee that there were 3 criminal charges against employees that came out of that situation.
Representative Harris.
Thank you.
Any other questions? Hearing none, are we ready to vote? All those in favor of House Bill 2711 as amended, going to civil full, say aye. Aye. Those opposed, no.
No.
The ayes have it. You move out to civil full.
Thank you, Madam Chair.
Thank you very
Committee.
much. Next, we have item number 3, House Bill 2698 by Representative Parkinson.
Thank you, Madam Chair Lady, and thank you, committee. And if at the
we hear a
indulgence of,
motion?
can I get a motion?
Motion, second.
Let me make sure I wake at least my folks up. Right. Thank you, Madam.
Properly motion and second.
Thank you, Madam Chair. About to
You're
turn around, and just walk
recognized.
out, just throw the cards in.
It wouldn't have been my fault.
It would not have been. It would not have been. And Madam Chair, for sake of discussing the bill, can we get the amendment on just to discuss that, so I can give a detailed discussion of what the bill is?
Motion on the amendment.
Does it rewrite the bill?
It does, yes,
Yes,
ma'am.
and let's get that on. So it's properly motioned and seconded. Do you have that drafted number?
Yes, ma'am. Let me dig it out of all my paperwork here. Yes, ma'am. 015119.
That's it. All those in favor of Amendment 15119 going on to House Bill 2698, say aye. Aye. Those opposed, no. The ayes have it. You are recognized on 2698 as
Thank-
amended.
Thank you, Madam Chair, and I really do mean that. But thank you, and to the committee, I say thank you also for allowing me to allowing this to be heard. Let me tell you how we got here. I was sitting in a barbershop, and this young man he came to me and he said he was in a fairly long relationship, and at the time he was in what he thought was a good relationship with love and trust. A little baby boy was born. He voluntarily acknowledged paternity, which means he signed the birth certificate. He had no reason to think anything otherwise, that that there was any infidelity or anything going on. He was in a good relationship. He was later told by the grandmother of the child that the mother had been with another individual. That disclosure made him decide to go get a DNA test. The DNA results said he was not the biological father of this child. He shared the results with the mom. They broke up. She then proceeded to put him on child support. They went to court. This is in Shelby County. He presented the magistrate with the DNA findings. The child at the time was 5 years and 1 month old. The magistrate said, and these are the words that he quoted to me. Those weren't the words. The magistrate said, somebody got to take care of him, referring to the child, and it's going to be you, and gavelled him out. The magistrate ordered child support, and at that time went back to the birth of the child, which put him in arrears as he walked out of that courtroom. Because he didn't catch up, his license was suspended. He was pulled over for driving on a suspended license due to child support. He was jailed, and while he was in jail for a little bit less than a week, he missed work, and because he missed work, he lost his job. He told me his life was turned completely upside down, and he had another child also that he was supporting, all because it was not disclosed to him that he was not the father, or that there was even a possibility that he was not the father. From this, we started doing town hall meetings on child support and paternity. Multiple town hall meetings were held across in Shelby County. These town hall meetings had attendance of 300 or more people that showed up to these meetings. Some of the stories were absolutely horrific. His story wasn't even the worst story, but some of the stories were absolutely horrific. At those town hall meetings, on the panel, we had myself, at the time another senator, we had members of juvenile court, Shelby County Juvenile Court, members of Department of Human Services, and members of Maximus, who is the child support collection agency in Shelby County. The reason why I had those different people, individuals on that, in that town hall meeting was because I didn't want them to hear these stories secondhand. I wanted them to hear these stories as I heard the stories, so that we all get the same information at the same exact time. Interestingly enough, there were some, but most of the testimony in the town hall meetings were not about slow payment of child support, but there were some. But most of them were about using the system for revenge and about voluntary acknowledgement of paternity. The intent of having these, from the meetings, from those meetings myself, Chairman Mike Carter, God rest his soul, Chairman Lundberg, and the rural district attorneys began to work on legislation to overhaul our child support system. When we began this work, peeling the layers of the onion back, we found out why there was so much apprehension to changing some of these laws. One of the first things I found out was that there was a 40% match of federal dollars for every child support order. And keep in mind, at the time, the order could go back to the birth of the child. And let me give you an example of one of the stories that came out in the town hall meeting. Young man, young lady in a relationship. They were in a relationship for 16 years. Don't run me out with rakes and pitchforks, ladies, but I'm gonna tell the story as it was told to me. The man got caught cheating. The lady got mad. They broke up. They broke up their they had a 15-year-old child. She put him on child support. They went back to the birth of the child at the time. 15 years in arrears at that time. And so he came out with a significant arrearages, I think in $85,000 in arrearages, walking out of the courtroom. We were successful in changing that law to restrict it to a maximum of 5 years unless there were circumstances. And I think, Chair Lady, you remember us working on this legislation, myself and Chairman Carter and Chairman Lundberg, that would, it would take it back to a maximum of 5 years unless there were circumstances that would have legitimately kept the woman from filing a child support order, such as domestic violence. Additionally, our child support system in Tennessee is 100% dependent on federal dollars to operate. These federal dollars, 52 million of them, come to the state of Tennessee for following federal law under the Social Security Act, 45 CFR 302.7 C7. That says for 4D recipients, or those referred to 4D, under this law, those individuals will, there are three components that the state must have in place for 4D individuals. Let me tell you what who a 4D individual is. That's a person that has been referred to child support court, or a person that is where a mother is receiving state benefits, and that is defined under the Social Security Act as 4D individuals. And so the federal government has said, in order to get this $52 million, you have to have three things in place: voluntary acknowledgement of paternity program, DNA testing, and married. If you're married, these will constitute paternity or acknowledged paternity. So let me say that one more time so we're clear on it. In order to get that $52 million, from the federal government, you have to have three ways of acknowledging paternity in your child support program: voluntary acknowledgement of paternity, which is right now signing the birth certificate; DNA testing for those that contest paternity; and if you're married, it is automatically presumed by law that you are the father. That's how you get the $52 million for your child support program. Those are for, per the federal government, 4D cases, the Roman numeral 4-D. Those are the cases that are referred to child support under our state child support program. Those are the things that they said you had to have in place. However, you also have non-4D cases. So let me give you an example of what that looks like. That could be, and I'm just using this as an example, two attorneys have a child. They don't have to go, they're not receiving assistance from the state, and they want to settle it themselves. Those are non-4D cases. Okay, so we're clear where the two parts are. Here's what we learned. Anyone, almost anyone, can sign a birth certificate under the voluntary acknowledgement of paternity as long as the mom is okay with it. Let me say that again. Anyone can sign a voluntary or sign the birth certificate, which is our voluntary acknowledgement of paternity program. Anyone can sign it as long as the mom is okay with it right now. Now, I want you to think about this, and this is only for unwed individuals, not for married people. So I want you to think about this, though. If anyone can sign that birth certificate, as long as the mom is okay with it, what about the actual biological father that wants to be a parent to his child? Once they sign that birth certificate, that person, right now under state law, is legally the parent of that child. And under our voluntary acknowledgement of paternity program that has been set up by the state, there are no safeguards to ensure that the actual biological father's name is on that birth certificate. Let me give you this. Studies, multiple studies, not just one, but multiple studies, have shown that 1 out of every 3 names on that birth certificate is not the biological father. And if those names are on that birth certificate and they are not the biological father, under our law and other laws, that is paternity fraud. Let me say that again. If you sign a birth certificate and you're not the father, the biological father, it is paternity fraud. Now, I won't speak on behalf of the Department of Human Services, but there's money involved in this. There's money involved to continue status quo. Now, let me say this on the record too. Let me publicly thank Commissioner Clarence Carter and his team for the engaged conversation, because we've been having an engaged conversation. We hadn't agreed on much, but we've been having an engaged conversation. But the common theme that I've been running into in this regard as to why we shouldn't adopt this legislation, and I will explain what the legislation does in just a half a second, is because, ma'am.
Could you please explain
Yes, ma'am.
the
Yes, ma'am.
legislation?
Yes, ma'am. Thank you, Madam Chair. So what this legislation would do to remedy this is it would say that you can still sign on the birth certificate, but that process will not be completed until you present the DNA findings stating that you are the biological father. And the reason why we want to do that on the front end is because, number one, if we don't do that, we are allowing people to steal the parenting rights of an actual biological parent, number one. Secondly, that child growing up has the right to have his biological and legal father listed on that legal document. Thirdly, if that child grows up and has a medical issue that he needs attending to that only his biological DNA parent can help him with, there's a chance that he'll never, ever find that. And he has that right, or she has that right. And so what this bill does, it will require that father to produce those DNA results and pay for it themselves, and so that we can know that the right biological person, father, parent, has their signature on that birth certificate. And with that, Madam Chair, I'm open for questions.
Thank you, Representative Parkinson, for that very explicit explanation. So, are there any questions? Chairman Farmer.
And yeah, I appreciate you bringing those pieces of legislation. But I'm just wondering, how's it going to fix the situation that you spoke of? Because as you were explaining that, and we talked about it a lot, you hadn't told me that story. And I actually knew a guy that this happened to in another district, to where he was on the birth certificate, had DNA test, and the judge said, you know what? I'm not letting you off the hook for child support, even though it was not his child. So how does this fix the situation where people are stuck in that situation now? I mean, how does this bill address the current folks that need that relief that are just stuck there?
All right. Thank you for that question.
You're recognized.
Thank you, Madam Chair. Thank you, and forgive me for jumping out there. I was just excited to answer the question. And Madam Chair and to Chairman, this bill will not fix his issue, just like it will not fix the individual's issue that told me the story. But what it will fix moving forward is us knowing and having it right on the front end. And so that we are not in that situation again. Because that DNA test, when that individual gets the results of that DNA test, he cannot, by law, sign on that birth certificate. It's paternity fraud. He knows he's not the father. But in the scenario today, an individual, the father or the putative father, I learned that new word, y'all. I'm not an attorney, but I stayed in the Holiday Inn last night. And so the putative father or accused father, under the scenario today, may or may not know, but the mother may know that there's a possibility he may not be the father. And so in the situation, think about this. You're the actual biological father. you're never even told that you have a child. So if let's say if you're military, you show back up, you know you had a relationship with this girl, you show up from overseas, you see this child, and in my case, this child has a big head like mine, square, right? And he looks just like me, right? And so you realize possibly you may have a child and you know you had relations with this person, you know, in that amount of time, but that child has been, or that responsibility has been told to another individual that he's actually the father. In some cases, the biological father would never have ever even been notified. But if we require a DNA test on the front end, we will know that this is the father, or we will know that this is not the father. And if it's not the father, then the mother can proceed to find out or you know, try to get the other fathers, you know, the other father, I'm sorry, y'all, the other father, the actual father, to sign on the birth certificate.
Chairman Farmer, did you have a follow-up?
Oh, I was just curious why we didn't go ahead and this bill didn't address that. It said, you know, that the court shall not order child support in situations where the court's aware and there's proof shown that DNA test. And I know the policy there, courts don't want to leave a child with one source of support, and I get that, but I just don't think it's fair to hold somebody accountable for someone else's. Well, let's put it this way, I just don't think it's fair. I don't think it's right to do that to someone. But anyways, your bill doesn't go there, and I just want to know that. So.
Very, very quick response
Briefly.
to the chairman, Madam Chair. This is a sticky subject, and I admit that. And we need steps to undo, you know, what has been done for a long time. And that is one of the things that absolutely have to be addressed, because even individuals that find out that they are not the DNA father, even afterwards today, like your client or your friend, these judges or these magistrates are still keeping the arrears in place, and these guys are being stuck with those arrears, and they are affecting people's lives. You know, this whole situation, we hadn't even talked about the trauma to the child, the trauma to the father, the trauma to the mother. Right? When these things are found out, you find out you're not the DNA. In the case of the guy that stopped me in the barbershop, he stated, Chair Lady, he said, I was hit first with the fact that I found out she wasn't being faithful. And this is somebody I've been in a long-term relationship with. Then I was hit with the fact that this child is not mine, devastating. Then I was hit with all of the falling dominoes from my license being suspended, losing my job, and which caused problems in my other house, my household now, with my child that I'm trying to support. That's actually my child, right? And so those things are happening. There's such a traumatic impact because we're not getting it right on the front end that we're ripping lives apart when we can be mending lives or keeping lives intact or keeping families intact by taking it out of the hands of that individual. Madam Chair, please let me just say this last thing. When it has been asked, you know, in fact, on the stage when we were doing the town hall meeting, the director at the time from juvenile court, he said, well, they can simply ask for a DNA test, and they can. By law, they can ask for a DNA test, and by law, they can take their name off the birth certificate in 60 days. And by law, they can rescind the voluntary acknowledgement of paternity in 5 years, by law. But if you're sitting in, and let's be real, let's be honest about this. If you're in a hospital room with your girlfriend who just brought forth a whole life, and she's holding that bundle of joy, grandma might be around helping her, and you're there, and so you're going to say, hey, oh, yeah, by the way, I want to get a DNA test. That's just not reality. You are doomed if you do, you're doomed if you don't, because if you get a DNA test, if you ask for it, your relationship is over.
Representative
Right.
Harris, did you have a question for?
Thank you, Chairwoman. So all this is very, very interesting. I'm listening to this whole dialogue that's going on, but And I know that if this bill makes it out, that next year you probably are definitely going to address the situation that Representative Former mentioned. But I have this Google Analytics thing that tells me anytime my name is popped up in an article somewhere. And so I ended up in a photo sitting in the background, just like the people in the audience right now, behind somebody in a court case. And so that's how I ended up seeing it. In that court case, I remember going to the court case, but it was for something else I was going to that was following that one. But there was a young man, he was 19 years old, 18, 19, I think he was 19 years old, but he was going through a very similar situation to this one where he was probably right at 18, 17 when he signed the birth certificate, but him and the young lady were no longer together, so they were trying to fix it because he truly signed it by, not mistake, but out of love, I guess. And so I've heard this before, so this was not the first time I've heard of this situation happening. But I guess my question to you was more concerning something that you mentioned earlier regarding the $52 million, and the way you stated it basically sounds like we make money off of another person's ignorance or mistake, that our state department is funded but that way, that partially. And so I wanted to ask you, was that what you were trying to say, or is that how it is presented right now? Are we, in order for our department to function, are we functioning off of money that we make because someone voluntarily signed a birth
Representative
certificate?
Harris, we're going to hear from DHS about that in just a few minutes.
Oh, okay.
Okay.
Thank you.
First, I want to go out of session and ask legal to explain to us exactly how a name gets on a birth certificate. So without objection, we're going out of session. Legal, you're recognized.
Michelle Fogarty, Legal Services. TCA 683302 states that immediately before or after the birth of a child to an unmarried woman in a birthing institution, an authorized representative of the institution shall provide to the mother, and if present, the biological father, written and oral information concerning the alternatives to, the legal consequences of, the rights and responsibilities arising from the completion of a voluntary acknowledgement. The information shall be provided to the birthing institution by the Department of Human Services, which shall develop the information in conjunction with the Department of Health. A videotape or audio presentation will satisfy the requirements for an oral explanation. I believe that's required under federal law, that they provide all of that information about the responsibilities and rights and legal consequences.
Yeah, and to legal, and thank you, Madam Chair. Do we know in signing that voluntary acknowledgement, do you give up your right to contest paternity in that acknowledgement?
I don't have a copy of the actual form, but you do have 60 days to withdraw. If you sign it, you have 60 days to rescind your signing of that.
Thank you.
Any more questions for legal? If not, while we're out of session, we're going to call up DHS, please, if you'll come forward. If you come, Marcia McShane and Charles Bryson, if you would, for the record, state who you are and who you're with, please.
Marcia McShane, Assistant Commissioner over the Public Information and Legislative Office over at the Department of Human Services. And I'm joined by Robert Duck, which I'll allow him to introduce himself.
Yes, my name's Robert Duck. I'm Director of Operations for the state's Child Support Program and the 4D Director for the state of Tennessee.
Would you like us to provide information or answer questions?
If you could provide some information, and then we'll take a few questions, please.
Sure.
Thank you. Thank you.
I, too, want to thank Representative Parkinson because he's absolutely right. We have spent a lot of time together talking and trying to figure out a way that we can try to address some of the concerns that he raised in his bill without us getting sideways with our federal regulations and laws and subject the state to potentially putting that $52.5 million in jeopardy that we get from the federal government in order to operate the Child Support Division at DHS. And again, we weren't able to reach a compromise, but I think a point was made about solving the original problem, which is if an individual is listed as the biological father and then later finds out that they are not. And that is a problem. Based on the information that we have, it is not a widespread problem, but it absolutely happens. As mentioned by legal earlier, there is a 60-day period where an individual who voluntarily acknowledged paternity through the voluntary acknowledgement of paternity process signed the form after being provided written information, oral information, that being reviewed with the individual. Both parents must agree to this and signing in front of a notary public. They have that 60-day window in which to rescind. The 60-day window is there, again, by federal law and regulations. It's not one that we could adjust without being in noncompliance and then again putting that federal funding in jeopardy. However, there is an amendment on, I believe, a different bill that Representative Parkinson has filed that would lift the 5-year statute of limitations, where when there are situations of fraud that has caused an individual to be responsible legally for a child that is not theirs, they would be able to challenge that even beyond that 5-year period that is still available after the 60 days in those situations of fraud. The Department of Human Services does not have any objection or see any issue with that being inconsistent with federal law. It's just the provisions that contradict what we're required to do in order to operate our child support division. So just a little bit more background. I just wanted to kind of go over a couple of things about how this all came about. So there was a big problem with children being born out of wedlock, and the problem got worse and worse over the years. For example, and this is a report from the federal government that's issued in 1950, there were only 3.9% of children born out of wedlock. By 2000, that number was up to 33. In 2020, just in Tennessee, that number was up to 43.8%. So there is, we're getting up on half the kids born in the state are born out of wedlock. And I think we all can agree that children need a 2-parent family to get the type of financial support, social support, love and affection, all of that. They're going to have the best chance of success and the lowest possibility of being dependent upon social services and living a meager life that can be supported by those services alone. So I think, Representative Parkinson, as well as us and everybody here can agree we need to try to address that issue and avoid those situations whenever possible. Because of that rising number, that's why the federal government determined something needed to be done to try to set up an easy way for individuals to establish paternity voluntarily. And if they can't do it voluntarily, a way for them to have a contested paternity situation. And then the third thing they needed to do was make sure that fathers who had not been told that they were the father of a parent or were trying to be kept out of the life of a child, that they had the ability to take steps to ensure that their legal rights as a parent were honored and respected. So those 3 situations were addressed with these laws that were passed, and that allows states like Tennessee to come up with their own plan, which we do, and submit that for approval. And that plan, however, must be compliant with the federal laws, the statutes, and the regulations in order for us to get our federal funding. It was stated earlier that our federal funding is, let's see. I'm trying to find, I think it was 40% match. And I'd like Director Duck to talk about that, because I think there was some information that was not accurate in what was shared, and we want to just make sure that we provide you all with the information that we have from our subject matter expert here.
Thank you. Yeah, so the $52 million that was mentioned is the federal match.
Could you state your name again and who you're with, please, for the
Sure.
record?
My name's Robert Duck. I'm the Director of Operations for the state's Child Support Program and the 4D Director for the state of Tennessee. So the child support program operates on a 66% federal match. So for every dollar that Tennessee spends, we get $2 from the federal government. So that $52 million that's been mentioned is the amount of federal match that we got last fiscal year. So I guess the concerns that we have is that the bill would possibly put us out of compliance with the federal regulations because we are required to operate a voluntary acknowledgement program in order to receive that federal match. And those funds, of course, are used to provide services for the entire state.
And if I may address a couple of other issues, there was a reference to a statistic of 1 in 3 names on the birth certificate not being the actual biological father. I'm not sure what that is based on. I've only seen some research that has been shared with me, but I know that we have information about what that looks like here in Tennessee. So we just wanted to share that with you as well.
Right, I'm not aware of that particular study about 1 in 3 being incorrect, but I do know that as far as the voluntary acknowledgement program goes in Tennessee, for the calendar year 2020, of the 26,773 people who completed a voluntary acknowledgement of paternity, we only had 34 people within that 60-day window come back and say, you know, I've got some concerns about whether or not I'm actually the parent of this child. And so it's very rare that we have people who take that opportunity within the 60-day window to challenge the VAOP that they've signed.
And I believe the only other issue I wanted to point out, and then we're happy to try to answer any questions, is in addition to the $52.5 million that is the federal matching money that we get, there is another concern with regard to our TANF funding and a penalty that could result in the event we are not compliant with providing a easy and simple way for parents to voluntarily acknowledge paternity without further court order. That is what our voluntary acknowledgement of paternity program is all about, is to ensure we comply with that part. So it has to be voluntary, it has to be easy. Right now, the situation is that, you know, shortly before or after birth, while the mother is in the hospital with the child, they are able to, they being both parents, have to consent, are able to review either a video or have an oral presentation, written materials, and then in front of a notary public, if they agree, they sign this. The information that's provided to them specifically states that if the father has a question about whether he is the biological father, he should not sign the voluntary acknowledgement form. It also makes sure that they are aware that this will attach with it legal responsibilities, obligations, and there's the 60-day period in which they can rescind that. So if, for example, we had a bill that was passed that reflects the amendment that has been presented with this one, that states that although individuals can voluntarily sign the acknowledgement form, that it only is effective for child support purposes if it is supported later by this DNA test, which, by the way, will cost these low-income families in some situations. Not all of these individuals will be low-income, but a lot of them will be. It's going to cost them the upwards of $200 to get this test, and the bill states that they would be responsible for that. That's a hardship on a family with a new baby. And if, in fact, we have to have the paternity test attached to it, that makes the process no longer voluntary. Instead, it's got a requirement with it that they have this separate test. Otherwise, it's not worth the paper that it's written on. We believe that, too, would cause us to be out of compliance, which could subject us to a penalty with regard to our TANF block grant that we get annually. That block grant is $191 million per year. If we were not compliant, that would mean we were penalized $3.8 million the first year and $9.5 million for each subsequent year that we are unable to acknowledge paternity at this 90% rate, which is what is required under the federal law.
Thank you. Representative Stewart.
Yeah, I've just heard some discussion of noncompliance. Is there a legal document that has expressed the noncompliance? I mean, is there, like, what would we look at to see the basis for your point?
At Representative Parkinson's request, we just followed up on that very issue, and I'll allow Director Duck to address that.
So I think you're referring to just the federal code that requires the voluntary acknowledgement program? Is that
Well,
correct?
Sir, I was thinking more, I was thinking that there might be some lawyer in the federal government or state government or somewhere that had conducted an analysis and said that there's going to be noncompliance, because I've heard kind of some speculative testimony about that. I'm wondering, has anybody actually looked at this and put pen to paper and said that this sort of program that Representative Parkinson is proposing, which to me seems like common sense and would solve a lot of problems on the front end, has anybody actually said that this would put us into noncompliance, or is that just speculation on the department's part?
I was actually contacted by the Federal Office of Child Support Enforcement, the Region 4 office, that Tennessee's part of Region 4. And they contacted me several weeks ago when this bill was introduced, and I wanted to have a discussion about it because they were concerned that it would put Tennessee into noncompliance. So we had that discussion a few weeks back, and it was the regional representative, our state specialist, and the regional program manager that this bill would make us non-compliant with federal law and subject us to penalties. They are actually now looking to get a letter for me that would explicitly lay out what the penalties would be for child support funding, as well as possible penalties for the TANF block grant that was mentioned previously.
Were these legal counsel that reached out to you, or are these people that are administering this program?
Yeah, there would be people who administered the program from the federal side.
And these are our in-state people?
The office is actually in Atlanta, so it's the regional office in Atlanta, and so they are assigned with managing the Region 4 states, of which Tennessee is a part of that. And they happen to monitor legislation for all the states within the region. If they see anything that's of concern, sometimes they'll reach out. So in my history with the department, this is the first time that they'd ever contacted anyone that I'm aware of and said, hey, this particular legislation's, might have some issues for your program.
Representative Stewart, one last follow-up.
Yeah, thank you, Madam Chair. So, and you said you're getting that input, you're getting some sort of written input from the department itself. Is that the next move, or what are you doing?
Yes, so the regional office has requested the central office in Washington, D.C. to contact the commissioner and see if they could not provide a letter for us specifically saying what the consequences could be for this Tennessee's child support program if a bill would, this particular bill would be enacted. So they are working on that for us.
Chairman Farmer, do you have a question?
Yeah, and I'm trying to put this together. It sounds like to me that what Representative Parkinson's bill would do, that it would operate within this rescissionary period. I think everything could be done with regards to the DNA test within the 60-day rescissionary period. So if we just enacted rules that would say, look, baby's born, out of wedlock, DNA test, all happening within the 60-day period, and then still saying, look, once the DNA test is over, you can still sign this voluntary acknowledgement, right? But this all easily can be done within the 60-day period. So we've got an easy process. We don't do away with the voluntary acknowledgement. It meets the federal standards, the guidelines there. So does this not kind of coincide, and could it not operate within and with kind of what we have now, just providing the extra layer of protection for those who may not be the biological father of these children? Is that not something that is this not how this operates or could operate? I'm just trying to just put it together here.
Sure, thank you for that question. We did look at that because, like we mentioned, we've been talking a lot and trying to figure out a workaround, if you will, or a work within, so that we could come together on a type of bill. The problem with the paternity test or DNA test requirement, which is how it's worded in the amendment, is that it makes the voluntary acknowledgement no longer voluntary because they're attached to one another. So you're absolutely correct that the 45-day period that's referenced in the amendment is within the 60-day. It's the attachment of the requirement for the voluntary acknowledgement of paternity, for it to be valid or enforceable, has to have with it the supporting DNA. So the attachment of those two is where we have the 90% compliance issue with TANF, and also We believe that the way the bill as amended is written, and based on our discussion with our federal partners, believe that it's their understanding that this is the case as well, that if you do not only have the simple way to voluntarily acknowledge without attaching it to anything else, then you run into a problem with compliance.
Chairman.
Let me ask this.
Am I getting that right?
Let me ask this question.
That's a good explanation.
Okay.
I don't think Representative Parkinson's bill says that you can't sign a voluntary acknowledgement even if you're
That's
not
right.
the father.
Well, the guidance that they would be provided is if you are not the father, you are not to sign this. So I think it absolutely allows people to sign the voluntary acknowledgement, but it also goes on to state that a voluntary acknowledgement of paternity supported by the DNA or genetic testing is the conclusive establishment. So the whole reason the voluntary acknowledgement exists in the first place is to have a simple, easy way to establish paternity. So it's towards the bottom of the amendment where they talk about in order to get that presumption of paternity that can be used for child support without a separate court order, that we run into an issue. I hope I answered that okay.
You did, and
Okay.
thank you.
Representative Bracken.
Thank you, Madam Chairman. I'm still trying to absorb all of this, and it's very difficult for me. I'm going back to 43.8% of unwed children somehow. How many child support cases or families y'all operate under right now, or monitor?
So it's not an exact number, but about 315,000 active child support cases and approximately 1.1 million individuals in the caseload within Tennessee.
Okay. Because I've gotten myself real turned around on what's causing non-compliance there and such. So I can't even ask another question, so sorry. Thank you.
Representative Harris.
Yes, and I too have also gotten kind of turned around on this, so I just need a little clarification. It is illegal to sign a birth certificate if you are not the parent, if you're not the father. Is that correct?
I know we have someone from the Department of Health here that they actually handle the birth certificate side of it. I don't think anybody signs the birth certificate anymore. I think the voluntary acknowledgement of paternity is what is signed, and then maybe the hospital puts the names on it, but they would have to tell you about
Okay,
that.
so it's not illegal to sign the voluntary acknowledgement of paternity, but it's illegal for you to sign the for your name to be put on the birth certificate if you know you're not the father.
I don't know. I don't believe that there's a cause of action for paternity fraud in Tennessee, but legal would have to answer that.
That's going to ask some follow-up questions.
Michelle, for Legal Services, I don't think there is an action for paternity fraud, but what we're discussing as being signed is the voluntary acknowledgement of paternity form, which specifically states that this is a legal document. Do not sign it if you do not understand what it means. And it also states if either parent is not sure that the man is the biological father, you should not sign an acknowledgement of paternity until you have a genetic DNA test.
Okay, that sounds like what Parkinson's bill is actually saying. But just for clarity, if a guy signs the forms after the 60 days, what do we receive as a state?
What do you receive after the 60 days?
Yeah, what does the state receive? Like, do we receive okay, great, that checked off a percentage of that we have to meet you said 90% cap or something, and then we receive our funding that way, or?
I think I can try to answer that for you. So the Office of Vital Records within the Department of Health is actually who keeps those records. So every year, we work with the Department of Health and report what's called a paternity establishment percentage. It's part of a federal report that all child support programs send every year at the end of the federal fiscal year. And one of those performance metrics is that the states must maintain a 90% paternity establishment rate for children who are born out of wedlock. If you don't meet that 90%, you could be subject to penalties to your TANF block grant. The VAOP process.
The Department of Health is going to speak for a few minutes.
Okay.
We're going to ask, do you have one last question?
We do. I'll pass.
Thank you, Madam Chair, and I will be brief. I'm just curious. This is back to our current witnesses. When were y'all first made aware, I guess, of this bill, and when were y'all first made aware that if it passed, we would be in jeopardy of multiple sources of federal funding?
I believe, although I was not with department at the time, that a somewhat similar bill and possibly two were filed last year. I don't have all the ins and outs of that. I know it related, and Representative Parkinson can help me out here, to the statute of limitations part of things, the 5 years. But I don't believe that it covered all of the things that are addressed here. So when it was filed, we were made aware of it. We monitor bills as they're filed with our legislative team. And then there have been several amendments. There have been some draft amendments that, one of which we worked on Representative Parkinson with, to try to come up with an amendment that, again, would address his concerns, but we also, felt that it would allow us to stay in compliance. So as those came about, we obviously got updated on those.
Okay, we're going to move on. We've spent a lot of time. I feel like we've had a summer study, Representative Parkinson. So we're going to move on to Health, please, Department of Health. If you would come up and state your name and who you're with, please. And we're going to give you 3 minutes to speak. And thank you for being here.
Thank you.
Thank y'all.
Good afternoon. I'm Elizabeth Foy. I'm a legislative liaison with the Tennessee Department of Health. My hope is not to take up 3 minutes in any way.
We'll give you a hand on that.
The Department of Health has a few practical matters that would be complicated by this particular bill. Specifically, Section 683301 requires a birth registration within 10 days when it is done within a birth center, typically a hospital. Following that, if a person enters a voluntary acknowledgement of paternity, that is attached typically to the birth certificate via an electronic attachment. The name of the child initially would be on the birth certificate, and if there's not a voluntary acknowledgement of paternity, then the mother's name would be the name of the child. If there is a voluntary acknowledgement of paternity, then the person who is acknowledging paternity becomes the child's last name, unless the mother chooses to combine their name or however they choose to, with a hyphen or whatever the mother's choice would be there. In this particular situation, we would have a delay in the naming of the child, or you would potentially have a birth certificate issued with one name, and then subsequently a DNA test that comes back and either requires a name change or mandates an alteration of that birth certificate. Now, that's not necessarily a problem, but it does require the Office of Vital Records to have additional touches on this particular birth certificate and would require additional people to review these certificates and ensure that they're accurately handled. There is a particular concern in regard to a DNA test coming to the Office of Vital Records. They don't necessarily have the ability to house a DNA test, and the particular bill doesn't specify the exact methodology with which that would be provided to the Office of Vital Records. That's all that I have to offer in regard to this particular element of the bill, but I'm happy to do my best to answer any questions that the committee has today.
right now with the birth certificate, well, first I question, you've raised some concerns with this bill, but has the department ever gone to the sponsors and raised these concerns up to this point? I don't know if you know that. Because I believe this bill is passed in the Senate, right?
It did, Representative Stewart, and the original bill as introduced had no issues of concern with the Department of Health. It wasn't until these amendments were added on that have become problematic. Some of my colleagues pointed them out to us, and we've been trying to determine exactly how they would impact the Office of Vital Records since that time.
Representative Stewart.
Because you could see why I asked. Well, okay, so point is, the amendments have been made to deal with another department. Now you're saying the amendments are creating a problem with your department. So the Department of Health is fine with the bill as originally conceived, is what you're saying. It had no problems.
That's correct, Representative Stewart.
Okay, thank you.
Any other questions? Seeing none, we're going back into session. You've got 1 minute for your final.
Madam, there was a lot of information that I need to respond to. Can I get 3, please? I'm asking, begging, just 3 minutes.
I won't
Grace.
say 1 because you know you're going to take 3. There you go.
Thank you, madam. Thank you, madam. Thank you for that. Thank you for that. Let me say this. Let's talk about federal statute. I have been on the phone with HHS attorneys, and I found it amazing that I can be on the phone with them, but they were having challenges, getting the information. This bill passed in the Senate. Chairman Lundberg passed this bill in the Senate. It's going to the floor tomorrow. No one from this department or that department spoke to Chairman Lundberg about this bill at all. Don't y'all find that peculiar? I found it peculiar. The amendment on Chairman Lundberg's bill is just like this one. No one said anything to Chairman Lundberg, but I guess I was the low-hanging fruit. So they came over here to fight me on it, right? But I will fight back. Whether it passes or not, I'm going to fight about this because I think it's important. HHS, the attorney at HHS told me this emphatically, showed it to me, showed me where it is in the language, in the publication leading up to the passing of that statute. The federal government lays out the minimum requirements that the states are to adhere to. Minimum. And then it's followed in statute that says the state government shall lay out the procedures with an S, the instructions, and the step-by-step actions for completion of a voluntary acknowledgement of paternity. That's what's not being told. So if we say that to complete the procedures for a voluntary acknowledgement of paternity, you must present a DNA test, HHS has said in their publication, I'm happy to send it to everyone else, I got this from the HHS attorneys, we only lay out the minimum requirements for states to follow. So this does not affect their money. I said, does it affect their money? We only lay out the minimum requirements. They can put what they want in their procedures and then send it back to us to look at. We did try to compromise. I tried my best to bend over backwards to compromise on this. I said, well, let's lay out so if they do the DNA test, then if they don't bring it back in 60 days, it's still a voluntary acknowledgement of paternity. They didn't want that because they're afraid of this quote unquote 90% quota that they're saying they have to meet. But the audit for that quota per HHS is for the accuracy and the procedures being accurate to make sure that these people reach that 90% quota. The process to establish parenthood for a father that's been in this situation is tremendous, especially if you are not well off. You have to hire an attorney. Can I close? Just a real quick close.
You just did close.
Ma'am?
I gave you 3 minutes.
Okay, yes, ma'am. Okay, I'll stop there.
Okay. How we? Thank you. Any objection? Hearing no objection. All of those in favor of sending House Bill 2698 2698 2698 as amended to civil full. Say aye. Aye. Those opposed? No. Ayes have it. You move out to civil full.
Thank you, Madam Chair. I got one more bill with you, and I promise you to be short.
It better be
I
short.
promise you to be short.
All right.
I promise you.
We're going to put you to the hill from now on. All right, next we have item number 4, House Bill 2699 by Representative Parkinson, and I see that you do have an amendment.
Yes, ma'am, I do have an amendment.
Amendment code. Properly motion and second. Do you have the code?
I think, do you have 013908?
No, I don't.
Which one do you have?
Which one do you have?
I got a few of them, but I only want to get the one.
15120.
15120. I have that one also. Yes, ma'am.
Excuse me.
But, Madam Chair, I do want to ask a question before we put this amendment on.
It's the same amendment that you put on the previous bill.
But the one that I would like to put on is the one that was filed first, which is 013908, and this is the one that DHS has no issue with.
Well, we're going to have to withdraw this one, right? Let's just put it on. Okay, so we've got a motion and a second on the amendment. Does
Yes,
it make
ma'am.
the bill?
Yes, ma'am.
Okay, so let's get it on the bill. All those in favor of Amendment 151, no, what's the number?
Would you like me to repeat it? 013908.
On to House Bill 2699, say aye. Aye. Those opposed, no. You're recognized.
Thank
on
you,
the
Madam
bill
Chair.
as
Simple
amended.
bill simply removes the 5-year statute of limitation for rescinding voluntary acknowledgement of paternity.
Any questions for Representative Parkinson? Hearing none, are we ready to vote? All those in favor of House Bill 2699 as amended going out to full civil, say aye. Those opposed, no. The ayes have it.
Thank you,
Move out to
Madam Chair.
civil
I really
full.
appreciate you
Right.
listening to the pitch. Thank you so much. Thank you, members. Thank you so much.
Okay, you're recognized on House Bill 2689, properly motioned and second. 2686, I'm sorry.
Thank you, Madam Chair. When a parent dies, their children sometimes become eligible to receive survivor benefits from Social Security. But in the state of Tennessee, the state considers these Social Security survivor benefits as income for the Department of Children's Services. There's $1 million intended for foster care that are used by the department to offset operations and services. This bill will require the state of Tennessee to instead hold these funds in a trust for the intended recipient until that child ages out of foster care, giving them a boost going forward. With that said, unfortunately, I would like to take this bill off notice with every intention of bringing it back next year. Thank you, Madam Chair and committee.
And due to the, I guess, time limits, we have to give up the room in about 5 minutes. We're going to roll all of the bills to next week without objection. So do I hear a motion for adjournment? So moved.